Welcome to the University of Paris 10. We want to show you today our project about the translation and the law and the problems the jurists can face when they translate concepts in other languages.
Hi, we are 5 students of the University of Nanterre in Paris. We are studying French law, Spanish law, and German law. We will speak about the traduction difficulties. We know that legal language is a technical language, a traditional language. As Cornu said, it's the ambiguity or challenge of being the same time knowledgeable and popular. The activity of traduction, despite of undeniable achievements, has still a lack of credibility and visibility. Like the comparison of rights, legal traduction requires crossing linguistic and legal borders. It is inseparable from the interpretation of the text, which reveals all its imperfection and silences. We will see in the first part the issue of the traduction and its methodology, and in the second part the challenges it faces with several concrete examples of American and English law, Spanish and Russian law.
So let's talk now about the stake of translation. First of all, we have to say that law, as a system of rule, is bound to language for expressing and enforcing them and is, in a way, limited by it. Accordingly, legal language has to provide targeted linguistic instruments by means of which the specific requirements of legal communication can be met. Some of these linguistic features are common to most legal languages, whereas others are language and culture specific and thus have a decisive impact on legal translation. As a technical language, every legal language has a specific vocabulary which is marked by its complexity and particularity, as it's bound to a specific legal system. So according to the Italian jurist Rodolfo Sacco, the translation was not a problem. In fact, it's only recently that the jurist understood that the law was a product of a culture and the language of law was created in this culture. With this observation, we could believe that the law was untranslatable. But the traductor disposed of many means to avoid these difficulties. So what are these difficulties, and can we have some examples? In the translation, the juridic translation is a difficult exercise because of the false friends. So what is a false friend? According to the dictionary Mounon, false friends are words with the same etymology, but with a different meaning. For example, evidence in English and in the common law has a different meaning as évidence in French, even if it's the same word. In fact, we say preuve in French. Furthermore, some words don't have any translation because the concept does not exist in other legal systems. For example, equity only exists in common law, and in civil law we don't have this system, so we can't translate this word. With this example, we can see that we have to find the goal of a law, of an institution. We have to find an equivalent and not a perfect translation because it's fast impossible.
Hello everyone, we are honored to interview Mrs. Kirsten Peglo, our professor in Nanterre, and we had the opportunity to have language courses with her, and we want to talk today about the problems of language and law she faced between her thesis and between the courses.
So the first question is, what were the main difficulties when you translated your work?
Okay, thank you, Maximilian, for the introduction. So let me answer to your question. Of course, the first difficulty was to translate German law written in German language into the French language. So this was quite a difficulty because you have to translate the concepts of German law into French language, and it's not only the language, it's also a problem of the French law, because the French law has not the same concepts as the German law.
Mm-hmm.
So you think it's more difficult to the translation part or the comparison part between the law systems? So it's the first of all it's the language, or it's moreover it's like the law, the comparison between law, which poses the most difficulties?
Well, it's difficult to say because, in fact, you have two problems, as you say, at the same time, and so you have to be a lawyer and a translator. Yes, you have to know the language and the law. And even if you understand the German language, you might not understand the German law. So you have to understand the German law, and even if you're a lawyer, you may not really understand special aspects of German law. And then there's another problem. The author of the text, maybe it's not very clear in what we have written. Maybe there's a problem in German law. It's not always black or white, but maybe it's a discussion about a special problem in German law. So how can translate this into French? And then you have, of course, you have the language, and you have to understand. If you are a German lawyer, do you understand? If you're a French lawyer, okay, you know the French normal language, but if do you know also the legal language? It's another problem. So you are confronted with two of these problems, and you cannot really say is the one or the other one is less important. Yes, it's a translation. It's divided in a few steps, and so you have first the language and the law, then the next language, and then the law in the language to which you will translate your text, your original text.
Okay. So maybe a last question. How long did it take it to you to translate all your work?
Oh, I'm really ashamed to say it because I was writing this thesis during 7 years. So I think maybe quite half of the time or a third of the time I needed for translation works. And but once you get a little bit used to it, it's like you're doing sports, you know. So it's like a warm up. It's going better and better, you know. And then you are used. Mine was in company law, so you get used to the vocabulary which is used in company law, yes. And that gets easier. My difficulty was also that I had to translate into French, and normally it's not my mother tongue, so that was another difficulty in the translation. Yes.
I have a last question concerning the courses. The difficulties for the students in your course, it's based on the language, or it's more based on the law problems? What do you think?
I think it's both too. It's if you're very good in German or French language, you might have less difficulties to translate because the grammar, the construction, it's easier to do it. And then it's yes, if you don't know the field of law in French and in German, in French and German law, in which you are the field of law which you have to translate, then it might be there's also a problem. So I cannot say it's very individual. It depends on people. Yeah.
Okay. So thank you very much.
Thank
you for the interview.
Thank you.
Law in juridical terms doesn't exist in the real world. I mean in the physical world. These notions only exist because the humans created them. They are human creations, and this is the reason why there are a lot of differences from a juridical system to another one. If the juridical culture are completely different between two juridical systems, then the differences will be more important. They are, for example, notions without any equivalent.
Now we are here talking about an essential problem, which is the lack of the exact equivalence. I'm here with Aurore, an Nanterre student in French and Anglo-American law. Law systems are the product of human behavior and a pure human creation. There are as many as there are cultures, each with their own concepts and terms. As thinking is usually reliant on language, this results in difficulties of translation, as illustrate idiomatic words commonly used in some languages but untranslatable as such in others.
Yes, and this is a very common problem for translators and for lawyers, because you might want to import a foreign concept or an institution, but you don't really have an equivalent word for it, or you have an equivalent word but it doesn't really refer to the same reality.
Okay, and now we will see terms without equivalent. We will start by clarifying the definition of consideration, which is in common law a necessary condition for a valid contract. This important element helps to differentiate a donation from a contract. A difficulty in translation and so in communication is the term trust in common law. It has been inserted in French law under the name fiducie, which refers to a similar system since it was originally imported from English law, but it's also quite different due to the inegalities between French and English law.
Yes, and you might want to translate fiducie by fiduciary, but these are really two different things. So another example of different translation also is the use of the word insolvency and bankruptcy in English and American law. The word bankruptcy in American law refers to both the situation of an insolvent, both physical and corporate, whereas in English the general term is insolvency, and bankruptcy only refers to physical persons in the UK.
Of course, British and American legal systems have a lot in common, and this is no coincidence. Having been an English colony, the American legal system is a direct descendant from the English system, especially from English courts and their case law. The UK and the United States have a common language, but ultimately they do not share lots of similarities anymore. After the United States gained its independence in 1776, it formed its own common law based upon the Constitution, while common law remains the primary legal system in England. One noticeable difference is that lawyers are necessarily called lawyers, such in Britain, while in the US a lawyer can do just about any civil or criminal matter. In the UK, most attorneys are either solicitors or barristers. The jurisdictions are also different. We have the Crown Courts in the UK or the District Courts in the United States.
A recorder is in the United Kingdom a lawyer who is named by the Crown. In the United States, a recorder is a suppliant judge. Another example is that a sheriff is the principal representative from the Crown in the United Kingdom, but it's the chief of the police from a specific region in the United States. A corporation is a commercial society, most of the time an anonymous corporation in the United States, but it's almost every time a public company in the United Kingdom. This brings us to mention a special problem in the lawyer profession, but also in a lot of other professions. It is called the polysemy. We could define it as the character of a sign that contains several types of content, several senses. It is a linguistic phenomenon of which it is advisable to be wary, but also not to overestimate the importance. The polysemy is not the same thing as the homonymy. Polysemy is a real danger for the juridical translator because he has to know all the main polysemy terms. If he doesn't know them, he will make some interpretations mistakes and therefore some translation mistakes.
Another example we have is the traduction of the notions of administrative law that hasn't an equivalent in Russian law. There is in French administrative law a notion that hasn't an equivalence. For example, the state property is a notion that designs the goods of a public person which have a particular regime of public law. So how can we translate the notion of state property in Russian? There are three possibilities. The first possibility is to use the Russian expression "земли обсего пользования" that designs the ground of common use.
This possibility only considers fields and grounds, but it's easily understandable for a Russian speaker. The second possibility is to consider that, as the notion of public domain is not translatable in Russian, we can use the French expressions state property and insert it in the Russian text. The third possibility consists in forging a Russian expression susceptible of giving sense to the state property. The goods of the state property belong to a public person. We also have problems of traduction in French and Spanish law that are the traductions of the legal institutions. In fact, the Spanish Tribunal Constitucional doesn't have the same legal character as the French Constitutional Court, that is not an institution, but a system of control and consultation. Furthermore, in France, we don't have an equivalent of the Tribunales Superiores de Justicia de las Comunidades Autónomas, institutions created after the decentralization of the judicial power in Spain, because in Spain there are 17 Comunidades Autónomas. In Spain, there is also the Audiencia Nacional that hasn't an equivalent in France, and in France we have the Cour d'Assises for penal issues, and it hasn't an equivalent in Spain. In Spain, the Audiencia Nacional that I talked before is a high tribunal which treats cases of terrorism or that have a national or an international importance. This tribunal includes a penal room, an appeal room, and a social room, but hasn't not an equivalent in France. So how can we traduce it?
The imperfection is inherent to the traduction activity. The traduction must be integrated into the legislative process from the beginning. Legal traduction is facing a profound change in the European Union with the emergence of European law codes. There are some groups working on the harmonization of the law in the context of the UniDroit Institute, the European Union, and the Common Core.
Thank you very much for listening to us. We hope you enjoyed your stay in France.
Bye.
Goodbye!